morning, and thank you for joining us. We're going to spend some time today talking about E-2 visa options where the investment amount is low or the cases are risky for some other reason. So a few things before we get started. Some of you may know that this firm was founded on an E-2 visa several years ago. Our founder, Ian Scott, is in the US personally on an E-2 investor visa. The firm is a full-service immigration firm, but we focus primarily on E-2 visas. We've processed hundreds of them, and we typically process E-2 visas that are higher risk, meaning ones that have lower investment amounts. And we also process at consulates around the world, although primarily we're processing in London and also in Toronto. We will continue our webinar series, doing at least 2 webinars a month on different topics. And at the end of this webinar, we're going to send out a few things. So one is the PowerPoint that you'll see here today. Another is an E-2 visa guide, which is a comprehensive guide going over the E-2 visa requirements, and also a link to where you can sign up for additional webinars. So for today, I will be presenting, and my name is Kelly LeGrand Weiner. I'm the managing attorney at Scott Legal PC, and I have processed many E-2 visas, particularly ones with lower investment amounts. So as we go through the presentation, if you have questions, please send them to the chat box. I will, probably, not answer them during the presentation, but we'll reserve time for questions at the end. And finally, this webinar is being recorded and will be made available on demand, and a link will be sent to you. So we're going now to get started with the presentation. So let's talk about the E-2 visa requirements. So the first requirement is you have to be a national of a treaty country. So there are several countries that have treaties with the United States that allow citizens of that country to apply for an E-2 visa in the United States. So you have to have a passport for that country in order to qualify. If you're an individual investor, you need to own at least 50% in the E-2 company. You also must make an investment, and there's a few different parts to this requirement. So the first is that you have to have a legitimate source of funds for your investment. So this can be any legitimate source, personal savings, a gift, sale of a house. If you take out a loan, a personal loan that's collateralized by your personal assets or is unsecured, this could also work. So these funds actually have to be at risk and irrevocably committed. This means that the investment cannot be just transferring a lump sum of money to a personal or business bank account. The money actually has to be spent on various startup expenditures to get the business to be operational. Or if you're purchasing a business, the money can be sent to the seller. Or can be sent to an escrow agent to be released to the seller upon approval of the E-2 visa. So this investment also has to be substantial. This means that, sorry about that, the investment has to be substantial. So this means that looking at the total costs of the business, the investment, has to be enough to get that business to the point of being operational. So for example, if you're starting up a service-based firm like a consulting company and, you spend money on kind of office space, equipment, maybe some marketing, some website, software, everything that you need to get to business to the point that you can actually operate that business is what needs to be spent. And kind of the lower the investment amount, the higher the proportion of the investment you need to spend. So if you have a very low investment amount, for example, $100,000 or less, then you need to spend a higher proportion of what's necessary to get the business up and running. Whereas if you had a very, very large investment, millions and millions of dollars, let's say we're starting a manufacturing plant with total costs of $50 million, you may be able to spend only $10 million. And the magnitude of the investment would mean that it's still considered substantial. When we're in the startup context, talking about typical E-2 expenditures, things like inventory, equipment, website, office supplies, warehouse, rent, and this is really going to depend on the type of business that you're starting. So, for example, if you're starting up a restaurant, then there's very specific expenditures that would go along with that, right? You're going to need to have a space for that restaurant. You're going to need to have licenses. You're going to probably need to have some amount of inventory. You may need to pay for renovations to a space. So these are going to change, based on what type of business you're starting, but there are some, strong expenditures that, apply to most businesses, and many of those are listed here on this slide. So when you're starting a business, then you need to invest everything necessary to get the business to the point of being operational. When you're purchasing a business, generally it's going to be considered substantial if you pay, the fair market value for that business. So whatever that business was being offered for on the open market will generally be considered substantial, as long as it makes sense in light of the financials of the company. If you're in a situation where you're purchasing a business from a friend or a relative, it's not an arm's length transaction, then you're going to want to have it's probably an independent valuation done to help support that the amount that you paid is actually the fair market value, for the business. So a business cannot be marginal, and this means it has to support more than just the investor and their family. What this translates into mostly is hiring U.S. employees. So the business, if it's a startup, would demonstrate through a business plan that it's going to be able to hire multiple employees by year 5 of operations. If the business is already running, you're purchasing an existing business, then that business should be able to show that it has a track record of hiring. Or if it doesn't, you would need to produce a business plan explaining how you're going to turn things around. The business also has to be real and operating. So this means that it's already taking in revenue, it's already operating. So if you're buying an existing business, then you would provide things like tax returns, payroll records, client contracts, business bank accounts showing commercial activity. If you're starting up a new business, then you don't need to show that the company is already operating to meet this requirement. What you need to show is that the company has gotten itself to the place where it could start operating once the E-2 applicant is granted their visa. So this is going to be things like a signed commercial lease, that you've established your business entity, you created a website, you've signed contracts, you've acquired all necessary licenses to run your business. So you're at the point where you could start to operate, once you're authorized to work in the United States. So another requirement is that the investor is going to develop and direct the enterprise. So the E-2 investor, needs to take a hand in running the company. Generally, also showing that you own 50% or more of the company will show that you have the ability to kind of, perform that, that function of developing and directing the enterprise. But the E-2 is not for people that want to move to the U.S. and retire. Certainly you can hire people to do kind of more of the day-to-day functions, but the investor themselves does need to take an active role in developing and directing, how the enterprise is running. And lastly, you have to have an intent to return to your home country upon the expiration of the E-2 visa. So generally, this criteria can be satisfied just by signing a piece of paper that says you intend to depart. If in the past, perhaps you've applied for a green card, or you have a pending green card application, or someone has filed an immigrant petition for you and the date is current, then that could be more problematic. But for, many applicants, ultimately you can sign a piece of paper to explain that you intend to depart, and you don't currently have the intent to apply for a green card, and that will, be sufficient. Let's talk about a little bit more about the E-2, requirements, how long the E-2 visa will last for. So, the options, we talked a little bit about this in the last slide. The options are either purchasing an existing business or starting up a new business. And that you have to be a national of a treaty country. So there's many treaty countries, from Europe, Africa, Asia, Latin America, the Middle East, there's a list on the Department of State website. So always good to go check there. Many countries, Australia, Canada, Israel, France, Spain. So can be a good option for nationals of many countries. And it's not based on where you were born. It's based on where you have a passport. There's a few exceptions. So there was a recent change to the law where, if you gained your passport to a particular country through investment, then you need to be domiciled in that country, for 3 years prior to being able to apply for the E-2. And this was a recent change, as many people were, getting perhaps nationality in some countries based on investment. And, so there was a regulatory change to ensure those people were domiciled there first. But for many people, that's, not the case. So how long is the E-2 visa valid? This depends on which country you are a national of. So there's something called a reciprocity schedule, and it will tell you how long you can be granted the visa for. So for many countries, people can be granted E-2 visas for 5 years, and then those can be renewed indefinitely. There are some countries where the visas are going to be granted for a less amount of time. Some like Bangladesh, where they'll only be granted for 3 months. Important to note that even if you only have a visa that's valid for 3 months, every time you enter on the E-2 visa, you'll be given 2 years maximum in E-2 status. So that's true if your visa is valid for 3 months, and it's true if your visa is valid for 5 years. So each time you enter, you need to check your I-94. So this is a document that shows what status you're in, and you can check your I-94 online on the government website. And make sure that you were properly entered in E-2 status and that you were given 2 years in status. And even if you have that 5-year visa, you still need to depart before the I-94 expires, and then you can just re-enter with your visa and get another 2 years. If you're somebody who, for example, who has a visa that's valid for 3 months, you stay for 2 years. Once you leave the US, you will need to get a new visa before you can re-enter. So, how much investment is enough? You must invest a substantial amount of money. There is no dollar figure of what counts as substantial. So there's some green card category like the EB-5 where there's an actual number that you need to invest. There is no minimum set amount for the E-2 visa. It will depend on the type of business. So, as I described earlier, they will look at a proportionality test. How much money have you invested versus the total cost to set up that type of business? And if you have a low investment amount, you want to be able to argue that you have invested 100% of the cost to set up that type of business, or close to 100%. Generally, you are able to kind of define for the consulate what are the startup costs, for that particular type of business. So, for example, if you're starting up a consulting company, you may be able to find articles, in business publications or industry reports that indicate, general startup costs for a consulting company, and that might be quite low. They may be, say, even something like $2,000, $10,000. Those amounts are just going to be too small for an E-2 investor visa application to be successful. However, you can utilize those types of articles to basically explain, hey, I've invested well in excess of this amount. I've gotten everything necessary to start up this business. Therefore, my investment should be considered substantial. You can also potentially have a CPA perhaps evaluate your investment and your business plan. Ideally, a CPA who works with similar types of businesses, and perhaps they can write a letter, opining that this is a substantial investment, and one that is likely to, be enough to get the company up and running. If you are buying a business, then the purchase price is generally, going to be considered the cost of, the business, the cost of the established business for purposes of the proportionality test. So if you pay 100% of the purchase price, then you've invested 100%, and that often will be sufficient. All right, so let's talk a little bit about strategies to deal with a low dollar amount. So what, you have to consider with a low dollar amount, kind of what is the overall strength of the E-2 application? Do you have, there's many requirements for the E-2 beyond just the substantial investment. And is the case strong in those other requirements? So do you have, strong proof that the company is real and operating, contracts, letters of intent, relationships with local business organizations that are speaking positively about your business? For example, perhaps you join a chamber of commerce, and start to make some networking connections, or they write a letter indicating that they're excited about your business entering their community as it will bring jobs. These things can all be very helpful. If the company is already operating, or you've already started taking in some revenue, you can show company bank statements indicating that. If you have kind of a very strong business plan, if you have kind of a record of success in this field, you've built similar businesses successfully, and the business plan reflects that. If you, shows you plan to hire U.S. workers, or if you've already hired U.S. workers, sometimes someone will, hire, for example, an office manager, an admin person to help them with some of these startup expenditures or startup activities, in the United States. And any money that you pay to that employee can be included as part of your investment, and is also good for showing you meet the marginality requirement. So let's look at a couple examples. So one is you are opening a business and you have a low investment amount. So if you, you've already hired 2 employees, the business has started taking in revenue, a pretty significant amount of 80,000 per month, and you have 10 clients. So in this case, it's very clear, there's a strong, argument that this should be sufficient, because even though your investment amount is on the lower side, you are showing that you've clearly invested enough to get the company to start running successfully. You have 2 employees, so you've met that marginality requirement. Also the fact that you're taking in so much revenue each month would show, both for marginality and real and operating. You have 10 clients, again, also, showing that there's a strong foundation for this business. So in that case, a lower investment amount would be less significant, because ultimately you have all these other parts of the case that are showing that this business is really viable and is going to make, a strong economic contribution to the United States. So if we look at if we contrast with the second example, you have a low investment amount, but you can't invest anymore. You're not going to hire anyone. And you want to come to the US, now. So in this case, there's it's certainly possible to get an E-2 visa approved with a lower investment amount and without having hired employees, or without having taken in revenue, or even sometimes without having client contracts. But it does make the case riskier. And you do want to be thinking always strategically about, if you have that low investment amount, how can you demonstrate in these other ways that you meet all of these E-2 visa requirements? So, in this case, if your investment's going to be quite low, it really can be very helpful to take some extra steps to try to bolster the strength of the other aspects of the case. If you can't get client contracts, perhaps you can get letters of intent. If you can't get signed letters of intent, perhaps you can submit emails showing interest from prospective clients. So you always want to be thinking about kind of what documentation can you provide, to show that you will successfully be able to run this business in the United States, and that no further outlays of investment are needed to get the company up and running. All right, so let's talk about some common E-2 visa expenditures. So there's, I think a really, good list here, good thing to consider. Every company at this point really does need a website. It's also something that consular officers will look at. They will Google the applicant. They will Google, the company name. They want to see what the website URL is, and see how developed is it. It certainly is possible to provide screenshots if the website's not live yet, or if it's in development. But this is generally quite an important expense. They want to understand, how are you going to market to your customers? How are they going to learn about you? How are you going to get business? Computer equipment, things that you would need for yourself and your employees, those are strong expenses. If you have inventory, for your business, that's a very strong, tangible expense. Furniture can sometimes be included, but really only if you are, if it's specific for the business, right? So if you're buying a dining room set for yourself and you are going to have a home office, this is not a strong E2 expense. But if you are purchasing furniture for a commercial office space, that can work. So I'm not going to go through the entire list, but there's several here. A couple to note, we have training courses listed here. This, I'd say, we generally tend to advise using very sparingly. You're not going to be able to include, for example, let's say you have a bachelor's in marketing and you're opening a marketing consultancy. You're not going to be able to include the fees you paid, for your degree. If you took a couple classes, a couple, specialized classes to help you get your marketing business up and running, that could potentially be included, but they're generally weaker expenses. People often also want to include a car or a truck. This is really only appropriate when the car is necessary for the business. So if you have a construction company and you're going to be hauling, materials around, if you are running a taxi service, if you're running a food delivery service. So it really needs to be directly related to the service the business is offering. It should not be just, this is my personal car and I need it to drive to and from, my house, or I need it to drive, to visit clients. So it's something to always discuss with the attorney ahead of time, especially if it's going to make up the bulk of your investment. If it's a very large expenditure on your investment schedule, it should really only be included in kind of certain circumstances. Let's talk about some investments that should never be included. And part of the reason we say this is that, consulates on their own websites will even have statements where they say, do not include, airplane tickets, do not include, travel expenses, do not include meals. Even though you could potentially argue, well, I had to visit the US and I had to visit a client. These are not good expenditures, and including them will actually weaken your case. So better to have a slightly lower expenditure amount as opposed to including these weak expenditures. Transportation, entertainment. If something's going to be, if you're paying out initially and it's going to be directly reimbursed by a client, they may not view that as at risk. And then expenses paid by related parties. So let's say you own two companies and you pay one of your companies to do some work. If you're the sole owner of each of those companies, you're not going to look on that favorably. Or if you hire your husband, or your husband's company, those types of things can be much riskier to include and can weaken your case. So let's turn, we process consulting, E2s for consulting companies very frequently. And so let's talk about some common challenges and tips for this type of business. So it is the case, of course, that you can start a consulting business by investing almost nothing. Many, many of our clients come to us and say, I have the knowledge, I have a laptop that I've already purchased. I don't need an office. I already have connections in my industry. I don't need to spend anything. So ultimately, while that may be true, in order to qualify for the E2 visa, it is a treaty investor visa, and you do have to invest a substantial amount. So even though, you could say, well, I really could get this business started with only, spending $3,000, that's just not going to be sufficient in order to get the E2 visa. So, you have to invest a substantial amount, enough that the officer feels comfortable that you are committed to successfully operating this enterprise. So that investment that's so low is just not going to qualify. However, we don't encourage people to just spend money on things that are not useful to them. What we try to encourage people to do is think about, in year 1 and 2 of your business, you're obviously going to have some operating expenses. Perhaps you're going to hire somebody to create a more robust website. Perhaps you're going to, buy some computer equipment for the employees that you plan to hire. Perhaps you're going to get a larger office space, to accommodate those employees. You want to think about those types of expenses and perhaps, make those expenditures a bit earlier than you initially planned. You can also prepay for office space. You can invest more in marketing than you initially planned. Perhaps you hire an employee earlier than you planned. Maybe you wanted to hire, an office manager in year 4 of year 1 of operations in the 4th month, but you hire them, before you apply, so you can pay them for a little bit. They can get your office set up for you. And then you can include any amount that you spend to pay them and any ancillary expenses related to that. So if you have to set up payroll, you need to get insurance, all of those types of things, can be, utilized to help bolster that investment amount, because you will need to invest a substantial amount, even when arguably you could spend very, very little or almost nothing to start the business. You have to do it in order to qualify for the E-2 investor visa. So you want to think about buying things that are going to be useful and relevant to your business. So perhaps just look at your planned expenses for the next couple of years and try to make some of those earlier. So let's talk about, this session is about kind of risks for low investment amount and also just risky cases. And a risky kind of industry for E2s is the real estate industry. Part of the reason is that consulates are very sensitive to the idea of, somebody just buying a house, holding it as a passive investment and saying, hey, I've spent a lot of, $300,000 on a house. I should be qualified for an E-2. So, a holding company, a company that really isn't producing any good or service, doesn't have any kind of active revenue generating activity, or even just kind of owning one property or two properties and collecting rents, that's really not going to be considered active enough. It's not going to be considered real and operating enough, to qualify for the E-2. So this is something, when you are thinking about, hey, I'm in real estate, I want to do an E-2 visa. We have some business types we've listed here that we've seen people use successfully. So real estate brokerage firm, property management company, if you're doing renovation, if you're doing construction, sometimes house flipping. Sometimes house flipping will be part of one of these other types of businesses. So maybe your business primarily does renovations, but also a piece of that business is going to be land development or flipping houses. And that's okay. That can all be worked into your business plan. But the key is that there needs to be enough activity to show that the business is going to be real and operating. And the other thing to consider is that for many of these types of businesses listed here, you do need kind of specific licenses, right? So if you're doing a construction company, you need a contract, may need a general contractor's license, and all of those requirements are going to be specific within the state that you're operating in. So for real estate, you want to do your investigation ahead of time. Look up what are the requirements where I want to operate, what licenses do I need, can I get them while I'm not located in the United States. Sometimes it's the case that maybe you need a social security number or you need to be a resident of the state in order to take certain tests that would get you these licenses. So in that case, perhaps you choose to contract, temporarily with, someone who does have the appropriate license so your business can operate until you get your license. Perhaps you hire someone who has that appropriate license, but that's something that you need to be planning for ahead of time, because consulates and USCIS are very sensitive to this idea, that they know that real estate companies, do often need some type of, license to operate. So another risky area is, equity trading companies, and it has a lot of the same challenges that exist for real estate. So, placing your stock portfolio in, the name of an LLC is not going to qualify. Kind of doing, trading for just a couple friends or, a couple family members. Again, the challenge is to demonstrate that you're really doing this on a large enough scale that it could be considered a real and operating commercial enterprise. And then also similar to real estate, it's a highly regulated industry. So depending on exactly what you're doing, you may need licenses. So you need to show the government that you have those licenses, or you've hired people who have those licenses, or there's a reasonable and short-term pathway to getting those licenses. So if, perhaps you can, get the license by taking a test within a couple weeks of entering the US, that's something that you could potentially, try to argue to the consulate, even if you don't have the license at the time of filing. But the ideal scenario is that you do have either the license yourself or you've hired somebody who has that license. Let's talk about some reasons for E-2 denials. So, one is low investment amount. So as we kind of discussed earlier, there are some investments that are just going to be too low. For example, we had a client come to us after they had applied on their own. They had spent $2,000 and then they had $98,000 in a business bank account. Even though this was a service-based business, this investment amount of $2,000 was just too low. So we advised this person on what else to spend money on. They ended up getting their expenditure amount to around $50,000 with $50,000 in the business bank account, and they were ultimately approved. So if you're in a situation where you have a low investment amount and you have the ability to spend more money, potentially you can just spend that additional money and then you can go back to the consulate and reapply with that additional money invested. Another reason may be nature of the business. So as we discussed today, there's some types of businesses that are going to inherently receive more scrutiny, where an officer is going to see the description of the business and, immediately kind of look at it a little closer to see, does this meet the requirement? So things like real estate, equity trading, consulting businesses as well. These are all, potentially riskier cases. With consulting businesses, the concern is that they don't want someone to come into the United States and just operate as a solo consultant. For the E-2, the person needs to be supporting more than just themselves and their family. They need to be hiring U.S. workers, making a substantial, economic contribution. So the concern there is, are you actually going to hire employees? So sometimes, for a consulting case, if it's very risky, very helpful thing to do can be to hire employees before you file to just answer that concern right away. So another reason for denial could be filing location. Venue is important. Different consulates, even though the law is the same, different consulates have different interpretations, and there is no set dollar figure of what is substantial. So there are some consulates that are used to seeing much larger businesses. They may not be as friendly to lower investment amounts. There are some consulates that frequently process, small businesses, and may be friendlier to that. So this does change too as consular officer assignments change every few years. So it is important to kind of discuss with your attorney, try to consider your options. Where can you apply? And is that, known to be, a friendly E-2 post or perhaps, not so friendly? The next two are kind of related reasons for denial. So if you've run a business in your home country for many years and it's similar to the E-2 business and you never hired anyone, they may not believe you that you plan to hire people. So in that case, a business plan may not be sufficient. Whereas for most startups, a business plan, can demonstrate you will hire U.S. workers. If you have a very long track record of not ever hiring and running that company, it may be hard to convince the officer that you actually do intend to hire. So that may be a case where you do actually want to hire an employee before you file. Related to this, concern over whether the business is going to create jobs for U.S. workers. So as I mentioned, consulting companies, they're worried you're going to come in, you're going to operate as a solo consultant. They want to make sure that the business is actually going to create those jobs for U.S. workers. Sometimes you can have issues with the adjudicating officer. Consular officers are human beings. They, sometimes, will have, a particular day where they're, not having a great day. We always recommend to our clients to be, as calm as possible. Consular officers do have ultimate discretion over whether to approve or deny the case. However, if you feel that, you weren't given kind of a fair interview or the officer didn't really understand, the application, it is possible to reapply. And they generally do try to give you a different officer. It's not, a right, it's not a guarantee, but many consular posts will try to give you a different officer than the one that initially denied you. And then finally, if you didn't meet the requirements at the time of filing. So, if the company wasn't, if you owned 30% of the company, and didn't control it, and the company wasn't owned by any other treaty country nationals, you're not going to qualify. If you haven't, kind of done anything to get the business up and running yet, or maybe you say, well, I have money in my personal account and I'm going to invest it. At that point, you just have not met the requirements yet. And so at that point, you want to kind of speak to an attorney, understand what the requirements are, and make sure that when you're reapplying, if you reapply, that you have an argument for how you've met each of the requirements. All right, let's move to some E-2 adjudication trends and hot topics. So COVID and the E-2 visa. Thankfully, this is becoming less of a hot topic. but unfortunately, it has not gone away entirely. So, there still are ongoing impacts on E-2 processing and on all visa processing, really. Consulates really came back online in terms of visa processing at different rates and are continuing to do so. So there are some consulates, for example, London and Toronto, that are essentially mostly back to normal. Perhaps there's, a couple weeks more delay than there was prior to COVID, but generally they are accepting applications, they are processing applications, and they're doing so in a relatively timely manner of a few months. Then you have some other consulates that have taken a much longer time to kind of get reorganized. So, each post has really been given that freedom to an extent to restart visa processing and prioritize certain visas, in the way that works best for them. But unfortunately, that does mean that there are some consulates that have extremely, extremely long waits for E2s. So this is a constantly kind of changing, it's always changing what the appointment availability is. And because E2s are a specialty visa, they really don't make, the processing times, public. There may be kind of, stated general processing times on the website, but that's always going to be in flux. So you do want to kind of talk to your attorney to understand, are we able to get any visibility on the timeline? But you do, generally, you will be looking best case scenario at a wait of a few months at least. So are consulates currently processing E-2 visa petitions? They are, in terms of the timelines. For example, right now in Toronto, generally you submit your application and then they will review it and they will generally call you to allow you to schedule an interview within about 10 to 20 business days. After that, interview slots can be available sometimes in the next month or 2 months. Again, this is constantly changing as we get farther, into the year and closer to the holidays. It will get a little more difficult. But that's, generally kind of to be expected at most consulates. If you're in a position where you really can't wait for a consulate appointment and you're already in the US, maybe you are, here as a student and your OPT is finishing up, or you are already here in E2 status and you need to extend or get a new E2 visa, but the timelines aren't matching up with your needs. There is an option to extend your status in the United States or to change your status from, a valid status like F1 to E2. The issue is you don't get a visa stamp in your passport. So what you would get from USCIS is a 2-year approval that extends your I-94 or changes your I-94 to E2 and allows you to stay in the United States and work for that 2-year period. But it does not permit you to travel internationally. So let's say you get an extension of status approved, but then you want to go home to Europe for the holidays. Once you go home, now you need to get a new valid E2 visa stamp in your passport before you can return. And just because USCIS approved your extension, it does not mean the consulate will approve your new E2 visa. Consulates, and USCIS view E2 visa adjudications completely separately. So if you've been approved by a consulate and you're now applying with USCIS, they will review it completely as it's a brand new case. And similar with the consulate, just because you were previously approved, they will review it on their own merits as if it was a brand new case. So in terms of choosing USCIS or the consulate, obviously during COVID, there were many reasons why USCIS was, could be more favorable if you were already in the United States, to avoid that having to travel. However, USCIS has a couple quirks. So one benefit of USCIS is they're much more open to low investment amounts, much lower than consulates will accept. So, we've had, some cases approved with, investments of $35,000, $45,000 with only a portion of that spent. Of course, past results don't predict, future success necessarily. However, it does demonstrate that USCIS is open to these lower investment amounts when it makes sense in light of the type of business. However, for USCIS, they take a much stricter view of the source and trail of funds than most consulates do. So most consulates are going to take a very holistic view. Let's say that you say that your investment is from personal savings from employment. You would just produce, your latest tax returns and then proof of you transferring that money to the U.S. business bank account, where it could then be spent on the E-2 expenditures. If you were doing that same approach for USCIS, they would actually want to see the money from your employment entering your bank account and being accumulated there. So if you're somebody who gets, a direct deposit into one bank account and it just stays in there and accumulates and accumulates, and then you make a lump sum transfer, that could be very straightforward. But for many people, that's not the case. Showing an accumulation of funds can be more complicated, as they may be transferring money to savings accounts, to investment accounts, all over the place. And USCIS would require you to trace those funds to see exactly where the money went. So if you said, well, yes, I've earned, money, from employment, but your bank statements aren't showing an accumulation of funds, you really need to investigate, well, where did these funds come from, and provide that source of funds. So USCIS can be much stricter about that. Generally, consulates can be better for that. They're going to take a much more holistic view, although there are some consulates that, are stricter about this. So again, always important to talk to your attorney about what are the requirements at your particular consulate. Another benefit of the consulate is that you will get a visa stamp. So many people, when they get the E-2 visa, they are not okay with just being, having to stay in the United States. And if you apply with USCIS, you're going to get, an approval that only allows you to stay in the US for 2 years. So between deciding, should I go with USCIS or should I go with the consulate? Very often people will choose the consulate because they want that visa stamp in their passport and they want the ability to travel internationally. All right, so some issues and complex areas that come up with E-2s. One common question, do I have to hire employees before I apply for an E-2? And the answer is no. It's relatively, clear in the Foreign Affairs Manual and regulations. You do not have to hire an employee, before you apply for an E-2 visa. If you have a startup, generally, showing that you have, a viable business plan that shows how you're going to make that economic contribution and hire employees within 5 years should be sufficient. That being said, there are some consulates that disregard this, that take a different approach. So it can be very favorable for your case to hire employees before you apply. And another benefit of that is that any amount you pay to those employees and any amount you pay to get those employees kind of set up within your company, all of that can be included on your investment schedule. And those are very strong E-2 expenses. Another thing that can often come up that can complicate a case is if you have a complicated source and trail of funds. This is mostly the case for, a USCIS filing. Let's say that, you have money from, a family member, but, it's just been sitting in a bank account for years and the source, kind of goes back many, many years. USCIS could come back to you and ask for all that documentation, even if it's 20 years old. So if you do have a very complex, source and trail of funds, it's likely a better option to apply at a consulate where you'll be able to take a more holistic approach, and often the documentation they'll accept, is not really this, is less than they'll accept at USCIS, whereas USCIS may want an audit trail of exactly where that money was. The consulate is not going to ask for that. Loans and gifts are both acceptable as sources of funds for the E-2. However, if it's a gift, you're going to have to get a gift letter and then also an explanation of where the gift giver got that money. The gift giver would have to be comfortable providing you with sometimes sensitive documents like tax returns, like proof of a property sale, because you do still need to show it comes from a legitimate source. With a loan, if it's a personal loan, from a family member, similarly, they're going to want to know, where did that family member get the money to give you this loan? And then also for the loan, important to note that the loan cannot be secured by the assets of the E-2 business. So this sometimes comes up when someone's purchasing a business. And there's an option for seller financing, where generally, the security for the loan is the business. So this can be problematic. Generally, while seller financing is not explicitly prohibited, what it means is the amount that was financed, under the seller financing is not going to count as part of your investment. So now you have to go back and say, well, if I bought a business for $300,000 and, 150,000 of that was seller financing, you've only spent 50%, of the investment, to buy the business, and they may not consider that substantial. So that's kind of the risk with that approach. Something else that can come up is, can you get E-2 visas for two investors? And yes, you can. If each person independently is going to meet the requirements, is going to invest their personal funds, it's possible to do this. You would have to own the business 50-50. That's the only scenario in which that can work. And also each investor should really have their own source of funds. So it's not, again, not prohibited, but definitely would weaken the case if one investor is gifting money to the other investor to make the investment. So another thing to consider is, whether there are changes to your E-2 business after filing. Unfortunately, sometimes people will think, well, I have my E-2 visa, so now I can kind of work anywhere in the US or do anything I want with the business. And that's really not the case. If there is a change in ownership, let's say that you come to the US and then you sell 70% of your business and you don't retain 50%, the company is no longer owned by treaty country nationals 50%, this no longer qualifies as an E-2, business. And your visa, although facially valid, is really not valid anymore. Similarly, if there's a change to the type of business and it is a substantive change. So if you were running a restaurant and you close that restaurant down and now, you are a wedding photographer, this is not going to be okay for the E-2 unless you went to the consulate or USCIS and you got approval ahead of time. So there is a process where you can notify USCIS of a substantial change and basically ask for an amended approval, or you can go back to the consulate and you can ask them to, review the change. Each consulate kind of handles this differently. Many of them will send you back to USCIS if you're in the United States. But ultimately, if there is a substantial change to the type of business, you do need to get approval to do that before you embark on that new type of business. Similarly, if you just buy another business, you buy the shares of another business, that's a separate entity and you're only qualified to work, or you're only authorized to work for your E-2 entity. So you need to be strategic in how you think about, those changes. If your business changes in a way that is kind of a natural outgrowth, like let's say you had a marketing consultancy and you plan to focus on clients in the finance sector, but actually you ended up getting a ton of clients, in the art world instead. That's okay, right? You're still doing the same service. You're still providing marketing consulting services. That's the type of thing where you really wouldn't need to go back to USCIS. You wouldn't need to go back to the consulate. So you do, want to, speak with your attorney, before embarking on any kind of major changes to the business, to consider, could these be considered a natural outgrowth of my services, or is this so substantial of a change that I really need to, go back to the consulate, go back to USCIS and get a new approval? Let's talk about family business purchases. So this does come up a lot, and it does, when you're purchasing a business, if it is a successful business, this can often make for a much stronger E-2 application, because you can show this is a viable business concept. It already has revenue. It already has employees. When you're purchasing a business from a family member, you're going to receive a lot of scrutiny. They're going to be very, concerned about whether or not you're really paying a fair market value. So you would want to get kind of an independent evaluation of that business. You would want, to make sure, like, it could not work that you're buying a business from your uncle and your uncle is gifting you the money. In that case, they were going to look at it and say, well, there's not really any money at risk here. So, it's possible to do this, but it's definitely something that is, much riskier. All right. So we've reached the end of the presentation, and I believe we do have a couple questions that have come in, so let's look at those now. All right, so somebody's asking about having to be domiciled in the treaty country, a German resident in Spain. So in this case, if somebody is, German has German nationality, that is a treaty country, so you could apply for the E-2. If you are domiciled in Spain, that's okay. You could apply in Spain. So the one place where this is going to be different, or a couple places where it's different. So one is the UK. If you have UK nationality, people who have a UK passport are only permitted to apply for the E-2 if they are resident in the UK. So sometimes they'll take a holistic view of this. So let's say that you grew up in the UK, you were born there, then you moved to the US on, worked there on an H-1B for a few years, then you worked in Europe, somewhere else, and then you moved back to the UK. That person might be able to, to go ahead and apply for the E-2. But if let's say you have a UK passport, but you never lived in the UK, you're not going to be able to apply for the E-2 based on that. But that's very specific to nationals of the UK. So in this particular situation, being a German resident, living in Spain, that would be okay because you're qualifying on the basis of your German nationality. The point I was making about being domiciled is that if you gained your nationality through financial investment, so it was very common that kind of Chinese nationals were, basically through investment becoming citizens of Grenada. If you do that, then you have to live in the country for 3 years and be domiciled there before you can utilize that nationality to apply for the E-2. So is having filed a DS-260 from Europe as a winner of the DV 2024 incompatible with the E-2? Not necessarily. I think that it's something that if you're at the DS-260 stage, like just applying for the DV lottery on its own is not going to be much of a concern. Some of it will depend on kind of where your number is. So I think it's something that you would need to potentially explain. I think very often with intent issues, you can kind of, especially with the DV lottery, you can kind of explain, you're keeping your options open, you're not sure what you want to do. So it would be a factor. It would be something that, a consulate could look at and ask you about. So you would need to kind of explain that, but I think that it's not, it's not something that would be a complete, saying, no, you can't apply for the E-2, but it would be a factor you'd have to consider and would slightly raise the risk profile of the application. So somebody's mentioning, you mentioned the wait time. What about priority processing? The last webinar I attended, they said turnaround is 45 days. So I'm not sure which webinar you attended, but you may be talking about the EB2 NIW for that type of green card, which is very different than what we're talking about today. There is something called premium processing for the first part. And you can pay the government an additional fee, and they will process your case within 45 days. For the E-2, premium processing is available if it's an extension or change of status inside the United States. It's not available at a consulate. So if you're going to a consulate, you're really subject to their timelines. You can make an expedite request, but they really grant those very inconsistently and very sparingly. If you're in the United States and you're applying with USCIS, then you can pay the government an additional $2,500 filing fee, and they will adjudicate your case within 15 calendar days. So premium processing is available for USCIS cases. And the 45 days is for EB2 NIWs. So you may have attended another webinar that was about, that type. But for E2s, it's 15 calendar days. Perfect. So I think those are all the questions that have come in. So thank you everyone for joining and for sharing, your questions. I hope you have a wonderful day. Let's see, one more question. If I want to invest 50,000 and spend 40,000 and intend to spend 10,000, would that be okay if I have contracts in place? I'd say that a total investment of 50,000 is quite low, depending on where you're planning to go. The intent to spend, so saying, hey, I have a contract and I'm going to spend this in the future, that that may not, that's not going to count as your investment. That 10,000 is still just going to be considered money in the bank account until it's actually spent. There's really not enough here to say this is a strong case or not. But I think that a total investment of 50,000 is going to be very, very low. Possibly would work with USCIS. But at any consulate, I think it's going to be a very, very low amount, and you would want lots of other, strong factors. So having contracts would be a good start. You would want some other strong, factors as well, as we've discussed, today. Perfect. Well, thank you very much, everyone. Have a wonderful day.